Now the fourth parable and last arises out of a journey which I took last week to Cambridge University in England for a meeting there of the Hague Institute on the Internationalisation of Law. And it is related. The meeting was called with experts from England, the Netherlands, the United States and Australia to look at the great concern that was existing in many countries about the loss of national control over law because of the way in which people are increasingly looking to law other than the law made by their own parliament. And of course, the point that was made at this meeting was that whether we like it or not, this just happens to be an aspect of the world we're living in at the moment. And in a sense, it's fed by and stimulated by the internet and the supply of so much data about law and about what other people are doing and about how other people are tackling very similar problems, and that because of that, it's just impossible to put your hand up and say, we don't want any of that. We don't want to hear about it. We'll just deal with this problem in our own special democratic way. Now, in great courts, like the Supreme Court of the United States and my own court, the High Court of Australia, you get divisions amongst the justices about this issue. And it's a serious issue about which I immediately concede there are points of view on both sides. And we saw such a division just a few months back in Australia, in the High Court of Australia, in a case which concerned the rights of prisoners to vote in the late election. The case concerned an amendment to the Electoral Act enacted by the Federal Parliament with the full power of the Federal Parliament. I'm not sure whether it was opposed by the opposition or not, but it was enacted, and it moved the barrier. Before the amendment, under the law which had effectively existed for the most part of the whole Federation, 100 and more years, a prisoner could vote in our elections because the prisoner was still a human being and, if so, a citizen, and could still vote unless the prisoner was imprisoned for more than 3 years, which is the electoral cycle, on the basis, presumably, one infers, that that prisoner will go out during the term and be part of the civic polity that is elected, that government is elected in the election. And in one of the measures of the last Parliament, that was taken away. Anyone in Parliament, anyone in prison was deprived of the right to vote, and that was challenged in the High Court. And it was challenged against a measure of our Constitution. And our Constitution has no great ringing Bill of Rights. It has no very clear, specific provision. The founders didn't specifically turn their attention to this issue. And so the question that was presented to the only power in our polity that had the power to decide whether the prisoners of less than 3 years could vote was the High Court of Australia. That's the way we do things. That's the way the Americans do things. It's the way of the rule of law. And we divided, and 4 of the justices reached the view that Parliament did not have the power, and 2 of the justices reached the view that Parliament did have the power, and we all expressed our point of view, and then the order was made which restored those prisoners to the list, and they all voted in the last election. That's the way we do things in these constitutional matters. But the point of my last parable is this. In reasoning to our various conclusions, each and every one of us called attention to decisions of other countries under other constitutions and other provisions dealing with the self-same matter, because legislatures in several countries had imposed big or short or long or small restrictions on prisoners voting in the general election. The questions arose as to whether that was compatible with the scheme of the Constitution and the guarantees of freedom. And in Chief Justice Gleeson's reasons, he referred to matters of history and raised the question, could Parliament restore the position before the Roman Catholic Emancipation Act? Would it be possible in this day and age to disqualify all Roman Catholics from voting, as had been the position in Britain until quite close to the 20th century? And would it be possible to exclude all Aboriginals from voting, which was the case under the Constitution at the beginning of the Federation? And in the reasons of Justices Gunn, O'Crennan and myself, we, like Chief Justice Gleeson, referred to the decisions of the European Court of Human Rights, which had declared how important it was that restrictions on the right to vote should be strictly proportional to a demonstrated need to limit the capacity of the citizen to take part in their political life of their country. Justices Hayne and Hayden were fiercely critical of the opinions of the majority, saying that it was impermissible to look to what other courts in other countries under different constitutions in different circumstances said on a matter, and that it was immaterial to study what they had said. But the difficulty of today, which judges of the minority view, like Justice Scalia and Justice Thomas and others of similar views in the United States, have to face up to, is this. By your technology, you are constantly bombarding us with the information of what is happening elsewhere, and constantly supplying us instanter, in a way that was undreamable in earlier times, with information about how other very clever people address, consider and solve analogous questions. And if there are differences, you have to take the differences into account. But to blind your eye and to close your ears to the message of the internet today is something that is just not going to happen. And it's very important for all of us in this room to appreciate that in every nook and cranny of our economic, social, legal and political life, the technology which is represented in this room is going to permeate and is going to play a part, mostly constructive. And we have to be careful in regulation that we don't impose rules or principles which favour particular and sectional interests and don't necessarily favour interests that speak up for their rights and for their interest in the use of the internet.